Let's roll. All right, we're rolling. Let's roll.
Hey, folks.
He said, let's roll, so we're rolling. That's JR, I believe. You want to say anything? There you go.
Hi, everybody.
Yeah, I'm saying hello, everybody, also. Oh, I got a weird hand. Obviously, this is not legal advice. This is just pure nonsense. I think I even put it in the title. This is like legal nonsense. So
legal nonsense.
Yeah, legal
That's
nonsense.
What we should call the show.
Don't rely upon anything that is said here. Do your own, whatever. But tonight, kind of as a sampling of what we're going to kind of do in the future, I invited questions from the audience.
Right. And we got a question from the audience that it's a really good question. I think we need to get right to it. Dispense with your jokes. Have at it.
Whoa, what happened? What was the question?
All right, you ready? This is a really good question.
All right.
It's from Blue 5. It says if
let me stop. Hold on, let me stop you first. All right. So I gave you like the preamble, don't rely upon anything. Now, this is especially true as to this, what we're about to do. Go ahead. Go for it.
So Blue 5 asks the question, if Earth joins the Galactic Federation, can alien abduction victims sue the aliens in court? Since we are going for made up answers.
Oh, yeah, no. This is not a made up answer.
No, this is not a made up answer.
Can I get a first crack at it?
Sure, go ahead.
You know what?
It's your show.
Yeah,
absolutely.
Yeah. I mean, whatever this is. This is like the simplest question in America. Maybe you're not American. I don't know. Maybe that's not.
We're a global organization joining the Galactic Federation. So we're Earth.
I know. I need more information because I need to know who's got the poll.
You are overthinking this answer, Richard. The answer is no. You wouldn't be able to sue because the court wouldn't have at that point have had jurisdiction. There couldn't be any kind of criminal charges because we weren't privy or we weren't subject to the sovereign's laws at that point, the sovereign being the Galactic Federation. I mean, think about it. That's what happened with the colonies when they, left the motherland, England. I mean, it's the same basic principle. So the answer is no, you would not be able to sue previous for alien abductions. Now, once we join the Galactic Federation, then absolutely you could sue, and there would likely be criminal charges for any of those alien abductions. Now, so Blue 5, I'm sorry if you've been abducted by an alien previously, you really have no rights here.
Now, of course, the caveat and little exemption is if you change your question and you just focused on the United States. Let's say the issue was with the United States. So if you were a citizen of the United States, could you sue? Right. And what I was going to say is the glory of the United States is anybody can sue anybody for anything in the United States. So yes, the answer is yes. Thank you very much. A fantastic opening question.
Yes, we appreciate your question.
Yeah, before we get to any other really pertinent questions, I wanted to quickly reference. I have a couple things I wanted to reference. If I could read it myself.
Sure, go ahead.
I don't even like this one, but I'm going to say it anyway. You know when the worst time to have a heart attack is?
No. When is the worst time to have a heart attack?
During a game of charades.
That took me a second.
Yes, I understood. When I told my friends and family that I was going to be a comedian, they laughed at me. They aren't laughing anymore.
No, we're laughing at you, not with you.
I know. This guy walked into the, I think it's the New York Public Library, and he asked for the books about paranoia. The librarian turned to him and whispered, "They're right behind you." And last but not least, apparently in the U.S., and this may be everywhere, the number one fear that people have is the fear of public speaking. The number 2 fear that people have is the fear of death. So theoretically, if you go to a funeral, most people would rather be in the coffin than give the eulogy.
Did you make that one up, or did you
I
find
did not. I did not. Did you like that one?
Yeah, it was pretty good.
Okay.
I'll give you.
All right. Okay. We wanted to, one thing that you and I have been taught, now we're back on. And if you see any questions as we go, please step in.
I keep track of them.
Okay. So one thing we had talked about was there was a Supreme Court case called Looper. And you've talked a little bit about it, but why don't you kind of talk about how you thought about it in general terms, and we can discuss it a little bit.
Well, I'll give you an example. And I was watching a YouTube show here a couple of days ago where they were talking about some things. It's a good show. I'm not going to mention which one because they had this part of the information was incorrect. And they were making reference to Loper and Jarkessi as giving the SEC more power because now they can have jury trials and there's some stuff they can do. And they were talking about Loper because Doug Sifu had made a comment about Gary Gensler. And the comment that he made about Gary Gensler was, well, look, Gensler's been threatening to ban payment for order flow. And the comment that they made was, well, Gary Gensler now has all this power because Chevron was overruled. And part of Doug Sifu's comments were, if Gary Gensler bans payment for order flow, I'm going to hold that up in court for, the next 15 years. And again, the comment was, well, now that Chevron's been overruled, the SEC has more power under Jarkessi and Chevron, and Doug Sifu can't do that. And again, I say it's a good show because it is, but they had that piece backwards. Gary Gensler, because of Chevron and Jarkessi, actually has less power. And Doug Sifu's comments actually make perfect sense because if Gary Gensler decided to ban payment for order flow, Doug Sifu could hold that up in court. And the reason he could hold that up in court is because what Chevron stood for is no longer valid law. And Chevron stood for the proposition.
Can I interrupt you for a second?
Sure.
So you're talking about that whether it gave the SEC more power or less power. So we have like an empirical kind of thing that I kind of discovered when I was looking at stuff for tonight. So since Looper was decided, the SEC, I guess, dismissed 8 enforcement actions that they had pending against their potential brokers within their own judicial system. Right. So they thought, and they haven't renewed them. So they haven't renewed them in court. So that's a suggestion, at least they believe they have probably less power and control.
Right. Well, it's not just the SEC, it's every agency. Okay. We focus on the SEC in our little world because we talk about securities. So that's the agency that obviously we're going to reference quite a bit, but it's all agencies. So Chevron stood for the proposition that when an agency makes a decision and someone sues because they don't believe that decision was the right decision, Chevron stands for the proposition that when that case goes before a judge, the judge has to show the agency deference in their decision making and the ultimate decision that they made. And do that by saying,
does that plaintiff have to be a gas station owner?
Yeah. Can be anybody. Anybody can sue for an agency decision as long as there's harm. And so what the judge has to do is the judge has to look at the decision that the agency made and ask a simple question. Was the interpretation under the law clear and concise, or did it leave room for wiggle? Did it leave wiggle room under the decision that was made? And if it left wiggle room, then the judge has to say, I have to show the agency deference in their decision-making process. And if that decision was reasonable, that's the end of the analysis. That's it. So the burden now shifts to the plaintiff to say, well, the decision wasn't reasonable and here's why. But the judge has to show the agency deference. That's what Chevron stood for. And so in a case like if you look at, Gensler deciding that he didn't want payment for order flow and he prohibited. Under Chevron, all he's got to show is reasonableness. That's it. He just has to show why it's reasonable to prohibit payment for order flow. But now Loper said, whoa, 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 whoa. Chevron actually took authority away from the courts, and that authority was granted under Article 3 of the United States Constitution, and therefore Chevron is unconstitutional and should be overruled. And so Loper overruled the judge showing agency deference. So now there is no deference. The judge can look at the situation and go, yeah, agency, I don't like your decision. I don't think it's reasonable. And I'm going to substitute my own decision-making ability based on all the facts and circumstances of this particular case.
Yeah. So
here's what the decision should be.
Let me intercede for 1 second and I'll let you go on. So
Sure.
It's not just that they're going to show deference. That means like if today the Department of Agriculture wins 95% of their disputes, in the future, it'll be probably significantly lower because it won't be them being judge, jury, and decision maker. Usually, and so it's not just that they lose authority; it will directly impact their success rate too.
Sure. And so Doug Seafood's comment.
And who is he, by the way, just so we're clear?
He's that he's a hedge fund. He's a Virtue. Right.
Yeah, and just for the record,
sure.
I have to always remind people about that. Doug Sifu also is a owner of the Florida Panther hockey team, and not this year, but the prior year, he watched one of my videos when we were talking about, I think JR, and we were talking about shorting or whatever, and we were like going off on whoever we were going off on, and one of the people I went off on was Doug Sifu. I was very nice about it. But he commented on the video and he said, the only thing he said was he thought my jokes sucked. That was it.
Well, he's not wrong.
But he didn't comment on the substance. I cursed him, and his team lost in the Stanley Cup Finals. So I feel vindicated. And go ahead.
No, I did not know that he was the hockey team owner until Jack started talking about it on one of the spaces. I don't really pay attention to anything outside of the Eagles. But at any rate, his comments in light of Loper make perfect sense, because if Gensler decided to prohibit payment for order flow and Doug Seafood decided to sue, it could be held up in court for a very, very long time, because, again, the judge doesn't have to show the SEC any deference anymore.
Let me ask a question to you. Your real opinion. Don't you think it would be advisable for Doug Seafood to change his last name to Seafood? Just a question. I don't know.
I don't know I don't know these people. I just know what they do and what they've done to the market.
He had a lot of nasty things to say about you. So,
whatever. But if I were SEC's lawyers, I'd be taking those comments and going, "Hey, Judge, this is a nefarious lawsuit. All he intends to do is hold this up in court. He said it before he even filed the lawsuit, and then let's file Rule 11 sanctions against his attorneys for bringing such a case."
And
so there's there's always counter moves, but in light of, I think there's a misunderstanding of what Chevron did and what Loper now does.
What do you think that people misunderstand about that?
Well, I think that they're putting too much weight into it. I mean, I forget, and I showed you the video, if you remember correctly, that Mary Bjorn in Congress asked the EPA undersecretary what rules they were going to retract because Loper found all these things unconstitutional, and he was like, what are you talking about?
It was incredibly boring, by the way.
Yeah. So there's a fundamental misunderstanding of what Loper did. I mean, Loper just took authority away from the agencies to make decisions and be shown deference by the courts when they get sued under.
Okay, so let's talk about, because I want to ask you about a specific example, U3 halt. Let me ask you about that. But before we get that, doesn't that mean, though, like in certain circuits, let's say a certain circuit of the court is anti-government regulation, anti-government agency, and they get the opportunity to rule on some cases. And there's a split amongst the circuits, which I'm sure there will be.
Sure there will be.
And the Supreme Court gets an opportunity perhaps to broaden the scope of things, because they've already kind of indicated some preference not to favor the agencies. So maybe like one particular circuit who really stretches kind of things might permit the Supreme Court to expand the impact of looper or looper, depending on whatever. Jerkesi.
Supreme Court cases are so damn difficult to pronounce.
I know.
Well, I think what's going to happen is, because there's going to be conflicting decisions in circuits on how this gets applied now, at some point the Supreme Court's going to have to come up with a standard of review. Very similar to what they do with constitutional provisions. What is it, reasonable? I forget the second one and forget the third one.
Like a fundamental fairness, and,
right? Well, reasonable basis, rational decision, and then strict scrutiny. That's what it is. They're going to have to come up with a standard of review for how the judge moves forward and when the judge is supposed to move forward. But one thing that they're not going to change, obviously, we know because of the composition of the court, is they're not going to give agencies deference anymore. But there has to be a standard of review. Otherwise, you can't apply this thing correctly. You can't have 94 sitting judges all coming up with different determinations, basically what amounts to the same rule. Because remember, all these agencies touch every state, so they're in every district court in the United States. So you could basically have 2 and 3 different decisions on the same set of rules that reach a multitude of conclusions. So you have to have some type of standard review, and at some point that'll happen.
All right, so I have to interrupt. So answering the question, and you have to think about this answer. No.
No, you didn't miss the good jokes, because
you have not missed any of the good jokes yet. Maybe they might be coming up soon. So before I ask you about the U3 halt, which I'm going to take you to, which is an MMTLP connected issue, so the Supreme Court starts to gather the cases for their next term, October, and one of the cases that they took was I think a producer of flavored vapes that was outlawed in a state. They just ruled that it was not, the FDA ruled that you couldn't do it. So the question is, should the court accept the FDA's determination, or does it need to send it back? Whether the Supreme Court should accept the determination of the FDA, or does it need to be sent back to the trial court for a redetermination? So that's another kind of a looper offshoot.
Oh, sure.
Yeah.
Well, I wouldn't be surprised if they don't return that decision with some type of standard and then send it back.
Yeah, it's very possible. The other 2 cases I saw that I thought were interesting and might apply, and then I'm going to ask you again about the U3 halt until we speak about it, there was 2 cases, one involving Facebook, one involving NVIDIA, where for private cause of action for securities violations under the Act, there's a question about the pleading standard and how strictly it has to be pled, the allegations. So right now it's to plead fraud, you basically have to plead fraud. So it's a very high standard, and you may not have access to all the information you need to plead it specifically enough. So there's 2 cases now before the Supreme Court where that's the issue, how strictly it has to be pled. Hopefully, the Supreme Court will loosen the standards to permit private individuals to assert securities claims and not basically make it impossible to do.
Because isn't it under the spoofing cases? Under a spoofing case, they have to plead it with almost like a different level of particularity, and they can't get any type of discovery until after the motion to dismiss is ruled upon in their favor.
Basically, yeah. The way it goes is, so, difference between, I'll just use California as an example. So if I file a case in the state court system, and I'm the plaintiff, so I've been aggrieved, I file a case, within 30 days, I can start discovery. No limitations, no nothing. I can get rolling. Hopefully there's somebody who's in the case that I can actually serve, but I can start rolling. In federal court, there's a conference you have to have, a meet and confer with the other side. It's called a Rule 26 conference, and you have to do that theoretically before you can initiate discovery, and a report has to be prepared and whatever. So that's usually, as JR said, that's after you've kind of had the pleading settled. So as a result, if you're the plaintiff, comparing my California state case versus my federal case, in my state case, I can go and get discovery. And I can, even if my complaint is weak to start off with, through those early phases of the case, I can generate discovery and get facts, and I can supplement my complaint. And even if it's attacked, I can kind of stay in. The federal court, I kind of am stuck. I better know what my case is from the start, because I'm probably not going to be able to get the discovery I need to kind of supplement that. So the cases now before the Supreme Court are trying to, or at least the issue is how strict that has to be, and should those be loosened up? And obviously, if they're loosened up, then it's for plaintiffs like us. That's to our benefit. And again, like, to the extent, and we don't know how the court's going to rule on this, obviously, but I would think if it's consistent with the anti-agency theme, then I would think it should be to loosen up pleading standards too, and to favor the individual. But it'll be interesting to see what the rulings are. I also kind of took a look, because you're going to talk about that U3 halt. I also took a look about Alpine, and to see if any cases like that, FINRA cases, were yet up and had been taken by the court. I didn't see any. Means that they could, but there may not be a case that's quite at the procedural posture right now that allows the Supreme Court to take it. Because, for example, Alpine, that last hearing, Alpine is the prime broker for GTII, and Alpine has had various problems, and an appeal is pending before the Court of Appeal in DC, and the oral argument was in March, and we have not had a decision. I checked tonight; there's no decision, so could be quite some time. You want to add anything?
No, as you know, I have not really been, other than talking to you, I've not kind of been following the GTI Alpine. I mean, you're my full, where I get all my knowledge from.
All right. So
someone just asked a question. Hold on.
Sure.
Can the lawyers contact the judge to see how long it will be before he will look at the order?
Actually, what you do, no. So the rule is you can't have, those are called ex parte contacts. So yeah, I see those sometimes in the movies. I see them though, and they're really effective.
Yeah,
I think. But no, it's a strict no-no. So what you would do, and if the question is, let's see if I can extrapolate on that question. Let's see if I can figure it out.
Probably shouldn't. Let it go. Let it go.
Oh, really? No, I was going to answer. I was going to answer this question anyway. I was going to say, somebody might ask me, when is that GTII order going to be done? And, can the attorneys call the court and ask? So, very good question. And so what would happen instead was you would call the court, you'd try not to piss off the clerk, and you try to gently get a response. Because in reality, I mean, the judge is the decision maker, but the clerk is really can have a significant impact on your existence in that court. So you certainly don't want to BS. I'm just going to answer the question before JR goes back to the U3 halt that he's been discussing in length. So I would expect that tomorrow I'll have information about when I expect the order to be signed. And that's all I can say today. But tomorrow we will be able to give you more detail about when in the future I expect that to happen. So stay tuned. Sometime tomorrow I will make it known. And then you'll know when you can kind of anticipate in the future, an approximate range. So if that was your question, that was it. And basically you have to finesse it. You call the clerk, you make nice, and hopefully the clerk can give you a general answer.
I would more with honey than you do with vinegar.
Yeah, you do. And unfortunately I've had times where the clerk, for whatever reason, hard for me to believe, but did not love me, and the experience was not great. So thank you for the question, though. Very great question. So JR, go back to your U3 halt. And Looper.
So, I didn't think we were going to talk about this, but
I know.
So if you look at so let's think about what the U3 halt was.
This is regarding MMTLP, correct?
Yeah. So if you think about what the U3 halt was, and not what it did to people, but what it was an agency decision. It was a decision that was made by the SRO under the guise of the SEC. And so you and I talked about this from one of the very first conversations we had was this right here. And the reason they put out that notice about what the U3 halt was and why they did it. Remember, they said it was a settlement issue. And you and I had a conversation. We even talked about it on one of the spaces. The reason they put that thing out was because of Chevron, because they had to show their decision was reasonable. And that's what they were going back to, which is why we think they violated 6940 or 604090. They violated 604090 or 6940, whatever the numeric citation is. And the reason they did that is because they needed to make up a reason to halt the stock. And so that was what they did. They changed the corporate action. They gave themselves a reason to halt the stock that was seen as reasonable. The reason that decision had to be seen as reasonable is because under Chevron, anyone that files a lawsuit under the Administrative Procedures Act has to show that it wasn't reasonable. But remember, under Chevron, the judge has to show the agency deference. So what do we know about Chevron at this point? Chevron is now gone. And the agency doesn't have that deference, doesn't have to, they don't get the benefit of the doubt here anymore. And so there's an argument to be made now that the U3 halt can be, a lawsuit could be filed under the Administrative Procedures Act, where an agency making an arbitrary and capricious decision and not acting in accordance with the law, and they don't get shown deference. That's the crux of it.
Okay, so I'm going to ask you a question. So what do you do with the immunity? So, and
they're not immune from regulatory authority. They've even admitted that in several cases that you guys have filed suit. Remember, they say they don't say they have carte blanche immunity. They say they have immunity from, they have immunity from everything but their decision-making process and their regulatory authority. They're not immune under the Administrative Procedures Act.
You like that act, I know.
I do love that act.
Yeah. So go on. Tell me something else.
Well, sky's blue.
The Eagles did the Eagles win last night, by the way?
No, the Eagles did not win last night. And yes, that's why we did not have the show last night, because I had a prearranged commitment. The Eagles were on and I forgot.
And what happened because of that?
What do you mean what happened because of that?
What, as a result of your decision, how did
they
the
lost?
Eagles, yeah,
they lost by one damn point.
Yes, at the end of the very end of the game, right?
Yep. And for those of you that are wondering why we didn't do it Sunday night, because Harry Potter is back in the movie theater, and I committed to taking my kids to see all the Harry Potter movies for the next 6 Sundays.
So you think, and we've talked about this. So you think an action potentially could be brought against FINRA? So that's another question. So does Chevron apply to an SRO as opposed to just a regulatory body?
Well, I think you'd have to sue both the SEC and the SRO. So you'd have to sue both FINRA and the SEC. But there was a law review article that was written a number of years ago after FINRA was created, which was because of the financial crisis back in 2007. FINRA was brought together from a conglomerate of regulators that had very similar authorities. I think it was two or three different regulators that had the same. There was a lot of overlap, so they created one organization known as FINRA. But the law review article basically said they have regulatory authority, therefore they are subject to the Administrative Procedures Act. And I don't think any judge would rule that they're not.
So do you think that a private individual, let's say, I'll make up a hypothetical. So do you think like an MMTLP shareholder could go and file an action against FINRA?
I do.
Based upon that they made a improper decision in their application of their rules?
I do.
And okay, let's assume
you have to have standing, right?
Yeah.
You have to
shareholder.
Have yeah. You have to be a shareholder and you have to have harm.
So the next question would be, so what's the remedy?
Well, I don't know what the remedy is. I would think that the natural remedy would be for a court to say, well, if we found that the U3 halt was arbitrary, capricious, and not in accordance with the law, then we have to lift the U3 halt. But what that looks like, I don't know. I don't know the answer.
Yeah, and obviously it's really complicated by the fact MMTLP doesn't exist right anymore. It was delisted, and right. Might they, find some other remedy? That was my question. Could you go through that hoop? Could you succeed and they give you a buck?
I think you'd have to let that up to the judge. I mean, there was plenty of evidence what the level 2 looked like. We know that there were trades executed in pre-market that morning, but that's way ahead of the bigger hurdles to get over. I mean, if you get over those two big hurdles, that's actually going to be fairly easy. Yes, it'll be fairly complicated, but it'd be fairly easy. The two big hurdles to get over are, making the argument that, yes, they are under the guise of the Administrative Procedures Act, which I firmly believe they are, and then showing enough evidence to the judge that the decision was a farce, that the decision FINRA made was arbitrary, capricious, and not in accordance with the law, such that the judge says, yeah, we want to look at all this evidence. We want to see it. You're going to discovery.
Yeah, it would be obviously a case in first impression.
That's right. It would be a case of first impression because I don't think FINRA has been sued under the Administrative Procedures Act since their inception. The other thing is this truly would be a test of Loper.
How about the issue of, and I remember there was a case, I don't remember where it was, either it was Atlanta or someplace in Georgia. Do you remember the case where there was a woman and the cops were chasing a criminal through her neighborhood? They literally went through her house, and when they went through her house, they damaged everything, and she sued the city or whatever for eminent domain, that they had made a taking, even though they were chasing a bad guy and they were in conformance with their own obligations and duties. There was still in effect a taking, and there had to be just compensation. So under the Fifth Amendment, the government can take, but they have to give you fair value, whatever that ends up being. That's sometimes vague. So I'm wondering, like in this example, could it be construed? I don't know. I'm just throwing it out. Could it be construed as a violation of the Fifth Amendment that action in declaring a U3 halt deprived shareholders of value that they never got compensated for, and was based upon the regulatory activity? In essence, it was a taking by the government.
I mean, there's always an argument to be made. whether or not it's a good argument, whether or not the law is in your favor is an entirely different story. I've always struggled with some of these constitutional arguments that say, the U3 halt was unconstitutional because of X, Y, and Z. I mean, they're just tough arguments to make. Well, let me take a step back. As you know, I'm a laser focused guy. I think, finding the right way to get over the terms of service. You got to get over that arbitration clause in the terms of service. How do you get it over? I'm not a throw the kitchen sink at them. I'm a, find that one good reason to violate it and then hammer that one good reason with the facts and the law, where the sitting judge looks at it and goes, yeah, I don't see how we don't get over this, arbitration clause. That's why, I've literally been thinking about the Administrative Procedures Act nonstop since day one. You know that.
Yes.
Because you and I have talked about it multiple times.
I think he dreams about it.
Do. The problem has always been Chevron. Now that Chevron's not here, my brain has been in overdrive with all of this.
Yeah. So just kind of like to bring it full circle. So we've discussed it and we're still discussing it, whether it's viable or possible to challenge that action. And, I don't know when I've heard about a 2-year statute of limitations. I don't know if it would apply, whatever, but we've discussed it. And I guess if it applies, we'll have to decide to make a decision before that date, whatever date that would be. I think it's December would be the
Well, I
date.
don't think I see, and I need to research this, but I don't know what the statute of limitations is under the Administrative Procedures Act, but let's do it right now.
Yeah, I was always too bored when I looked at it to kind of get through it. And we are going to talk about GTII in a second, by the way.
Well, let's talk about GTII because it's 806.
All right, okay. Yeah, so I mentioned the order that tomorrow I'm sure I'll be able to kind of give you a real heads up about when the order will come out. Anything's possible that it doesn't come out, but I'm expecting that it will. And so sometime tomorrow, I will let you know when to expect that. Separate and apart from, go ahead.
6 years.
Okay, so we're cool.
That's what I thought it was.
All right,
6
so
years. Let's take one step back and then we'll get back to GTII. Statute of limitations under the Administrative Procedures Act is 6 years. That's what Richard and I are talking about.
Yes. Yes. And we were all talking about a 2-year because there was a 2-year statute also that applies. So you could have different claims and they're governed by different periods of time. And so you might file 6 claims, maybe 3 are barred by a statute of limitations, 3 are not. And I just made that up. So we have the order next. And I haven't seen a final, obviously, I haven't seen a final executed order, or else I would tell you that. And as soon as I do, I'll let you know. 2. So they filed, we talked about it. They filed last time, I think, when we spoke. I like when they say we spoke. Whoever we is, I don't know. QUI.
Not the judge.
I think that's QUI, by the way. That's how it's spelled. They filed a motion for reconsideration. I think I gave you a key word. I said something. I can't remember what the word was, but I said blank, blank. I'll tell you this afterwards, but I can't tell you now. So I'm repeating that blank, blank, chicken McNuggets. Just remind me, just yell out chicken McNuggets next time. And I'll let you know what I couldn't tell you before. That's the only way it makes sense. Listen, I know certain stuff, right? So certain stuff I may not want to disclose for our collective benefit, and it'll become more obvious when time passes. So I'm trying to be cryptic. Yes, I am trying to be cryptic because, we try to be transparent. We will disclose everything, but there are sometimes you want to hold on to information for at least, for various reasons. And we'll discuss those reasons after the fact. All right. So motion for reconsideration is pending. They only asked for, they used one basis, the 10% shareholder amount. I think they're going to lose on that anyway, but there were 3 other bases. So I don't know what it was. The other issue was Luke Rabari. They didn't want him excluded from the receivership. Whatever. I'll leave it at that. I won't comment. It's not really necessary. I think the judge, if it probably be reflected in the judge's order, so we can deal with that. What they did beyond that, and this happened yesterday, they filed motions to dismiss in Nevada. And the 4 individuals, I believe, I don't know if the company did, but the 4 individuals, there's 4 directors that were named, including Mr. Reichman, Griffin, Benintendo, not the Frank Benintendo that always gets confused, but a different
Frank.
Yeah, I know, but a different Frank, and a Mr. Gilbert, and those 4. So they filed. So their responses. That's another director. Whatever.
Never even heard of that poor guy. He probably has no idea what the hell's going on.
Listen, he's like 88 years old.
He definitely doesn't.
I feel bad. Yeah, he's the youngest on the board. Just kidding. Just kidding. So they filed motions to dismiss. The basic motion was, they said, Nevada courts, you do not have jurisdiction over us because we're not Nevada. And in the law, there's something called jurisdiction. It's really boring. I think I skipped most of my civil procedure class because it's really, when I say it's boring, I'm being generous. I'm really being generous. But part of it is you have to have certain contacts with the state. That's kind of what gives the state the right to have power over you and make decisions. But in certain states and certain situations have these statutes that let them assert jurisdiction. And basically, you're consenting to jurisdiction in the state. And one of them applies to like officers and directors. So like in Nevada, if there's a Nevada corporation and you're an officer and director, it appears you don't really have to have those kind of contacts and you've already consented to jurisdiction. So I'm not the only one that thinks that's a losing argument. So I think they're going to lose. The alternative argument they raised, and this is like a first-year law school thing that you hear about, but you never see, is they raise the issue of forum nonconvenience, right? How often that's a first-year law school, right?
Yeah.
Basically means, maybe jurisdiction's right where you say it is, but it's so inconvenient for me because I live on Pluto, and it would be a long drive to go to court in Georgia every day. And that's basically the argument. And part of it also is, Mr. Gilbert, for example, he's 88 years old, and it's a long drive from New York to Vegas. Now, of course, there's ways around that, right? Because you don't have to appear in person. You can appear by Zoom. So there's ways around that. What's also interesting, I think, it makes it kind of a difficult argument, especially making that argument, is in the action they filed against me. It's not in New York. It's in California. So if flying out to Nevada was bad and inconvenient, I think from New York, I'm not really good at geography, but I believe California would be farther from New York than Nevada. Do you have an opinion on that?
Well, my own personal opinion is there shouldn't really be any more forum nonconvenience because we live in a virtual world these days. I mean, I oversee a region that's in a different time zone and I can't get to by driving, and yet I still manage 7 different people. So this notion that any forum is inconvenience, those days are over. And any judge ruling in someone's favor, making that argument, I think is old school.
Yeah, I think it's a loser motion. And the other point is, and this applies to everybody out there who's a GTII shareholder, they're spending money, right? They're incurring legal fees, and the question is, whose interest is that in? Is it in the interest of GTII shareholders for GTII to be? And I don't know if GTII is backing the fees, so I don't know that. I suspect they are, but I don't know it for sure. But if GTII is backing the officers and directors and covering the defense when they've purportedly, it seems like, based upon what that court in Nevada said, they engaged in some stuff they probably shouldn't have. And it appeared that at least some of those claims or some of the findings of the court were intentional, that they didn't just like make a mistake. It was intentional. But if that's the case, why should GTII be paying for defense? Why should they be spending money, in that? And so that's a question. And who has that decision making at this point in time? Who at GTII as of today? Because there's no order. We know what the courts indicated, right?
Well, the board, right?
Yeah,
we know what the courts indicated.
Yeah. So, but and everybody, in the way it works in the legal world, yeah, it's not officially an order. But if you took action right now, pending the final sign off, the judge would flip.
Sure.
The judge would flip out. So
right, because the judge is already constructively ruled. The judge has pretty much said it's going into receivership. You all need to hammer out the details of what that looks like, and I'll sign off on the final order.
Yeah. So the point is, then why spending money? How is that good for us as shareholders?
Well, it's not. And I think the receiver, whoever the receiver ultimately is, I mean, that's going to be one of the first things the first job of the receiver is to get the books in order.
Yeah.
And then to figure out what the cash flow is. And if the cash flow is being used for senseless, baseless lawsuits, as the receiver, he's got a fiduciary responsibility to say, no, we're not pursuing this. Get it off the books.
Yeah, I guess that was the point I was going to make. So now the CEO, as far as I know, the COO and the CEO are Mr. Rabari, right? Yes. The answer is yes to that question. And that being the case, by the way, this is not like I haven't directed this already. So I sent a letter or an email to counsel who's involved in Nevada in my action. And I said, I don't remember if the demand was specifically as to Mr. Rabari or it was the GTII or both. Not sure. But I made the demand. I said, you're pissing away money. It's our shareholder money. It's based on apparently intentional misconduct. How do you justify that? So stop it. You have a fiduciary duty. Cut it out. That was kind of my direction. As far as I know,
let's say hypothetically, the order was issued today.
Yes.
Signed by the judge. Would you then send the same letter to the receiver?
I would definitely have communication with the receiver.
I was just curious.
Yeah. But the receiver doesn't he's not obligated to me. He's obligated to the court. So he, my understanding, he's going to make the best decisions for the benefit of shareholders. That's my understanding. But and even though I think I'm professing what's in the best interest of shareholders too, but they may not be the same. But I think in general, in the nature of the general scope of things, that we're on the same page. That's my impression. But my impression also is then getting back to this point, because I think there may be a inaccurate conclusion amongst GTII management who has a fiduciary duty and who does not. And people may not think they have risk. And now I think this is me, my opinion for today. I think spending a dollar in defense of the intentional misconduct found by the court, okaying that as a breach of fiduciary duty. That's my opinion. I think there's no justification for doing that. Of course, I don't think, of course, and obviously I'm biased on this one. Of course, I don't think there's any justification for them pursuing the action in California against me. I think that's ludicrous. And I think additionally, that's point two, that's a secondary issue. Spending money obviously it benefits me personally. I accept that, whatever. But if somebody came up to me and they asked my opinion about Mr. X and they gave me the same scenario, I would say they were nuts for pursuing the action, and I would tell them to cease. And by the way, I've asked them to cease, and to this point in time, they've not responded. But I think that too is also certainly somebody could argue that could be argued as a breach of fiduciary duty for spending money. One of the issues that management often gets stuck with is committing wasting assets. And this kind of, to me, which also the next step would be, does that mean that there's a conflict of interest between the interests of management and the interests of shareholders?
How can it not be wasting assets? They have no income. They have nothing.
Well, I mean, you could
theoretically,
theoretically, let's say they don't agree with the decision of the Nevada court. Let's say that's the conclusion. But to be honest, in their motion for reconsideration, and this is it. I mean, I found it kind of bizarre, but it is what it is. In their motion for reconsideration, they didn't attack this substance. They didn't argue like, no, we didn't breach our fiduciary duty. No, we didn't do this. They didn't touch that.
They didn't argue any of that.
They just let it sit. I don't think that's a real strong position to start off with, So with that being the kind of like the foundation, I think that spending $1 more is really a breach, in my opinion. And if I were representing them, that's what I would tell them. So the other issue you have that raises is, why are those attorneys filing these motions that are most likely just dead bang losers? I know that in some of the prior ones they've filed, I've seen like gross inaccuracies, like factual inaccuracies. So I don't know the reason, because you could have a real reason. I mean, they might be trying to make a record for an appeal, and this is all stuff they're trying to do. Okay. I mean, that's I understand that. But also sometimes, lawyers, I don't know, like you would never do it, and whatever. But sometimes lawyers do things because it generates fees. I'm not saying, I'm not saying, sometimes I've heard that they do that. So I'm not saying that these guys are, because I really don't know, but they're doing a lot of activity, and that's coming out of our pocket, apparently. If I'm incorrect, by the way, on that, I'd like somebody to correct me, whether it be, if it's a law firm watching this video, hello. If you're not being paid by GTII, then please correct me, because that would change my analysis. If like a private individual was paying, that would be a different kind of evaluation. It would still be problems like the conflicts of interest we're talking about, and it wouldn't change kind of the conduct issues that we're talking about, but it would change the facts if GTI is not paying the fees. The reason why I think in part that GTII might be paying the fees is because there's an indemnity agreement that for the benefit of Mr. Rabari, dated July 2nd, that's from GTII. So it's not from an individual, it's from the company. So I'm suggested to me that maybe that the GTI is paying fees. So I will keep you apprised. I'll let you know tomorrow, again, when the order will be coming out. And hopefully I will know tomorrow when the order will be coming out and let you all know. Two quick follow-ups I wanted to reference. We talked about it really briefly. JR wasn't aware of it, but the security lapse at the golf course. There's a golf course I played in high school. It was in Brentwood, California. The setup was exactly the same as that course in Florida. Had like shrubbery around it. Not pretty. Again, it's very disturbing, I would say, that the Secret Service nearly got. I guess they did their job, but it didn't seem like it seemed like they created an unnecessary risk was created, and that was a problem. So it is a problem. At least I see it that way. I had a brief conversation. Oh, I want to do this first, and I'll do the other one. So there also was in Lebanon, I guess today, there was a whole series of exploding pagers. I don't mean to laugh. I'll laugh about it. Yeah. But it was, the irony of this is it reminded me of something. So I live in California. I've had work in Vegas before because it's very close to California. And in the 80s and 90s, before cell phones, 80s and 90s, yeah, before cell phones, there was this guy in Vegas. His name was JJ, and he was called the king of all pagers. And he would give pagers to everybody. So all the hookers, the gamblers, the cops, whatever, he had everybody outfitted for that. And what struck me after hearing it today was JJ was an Israeli. So he was
a supplier.
He was the Israeli pager guy. So he was like a big guy. And today we had the pager issue in Lebanon. And so that was pretty wild, to be honest.
Right.
Yeah. I don't know if apparently they were able to hide. This is like speculation, but they were able, this was a new brand of pagers, and they were coming in from Taiwan, and apparently they were able to intervene and get the shipment and install a little explosive device in the phone, in the pager, and then send a message, and it would trigger somehow it would trigger it.
Pretty, is that what they're finding out happened? I just thought they malfunctioned.
Yeah. No, they it was intentional, and it was timed. Yeah, timed at like 3:30 in the afternoon. Everybody, and they'd send a message, and somebody would look up, like, they would pick up their pager. I think that's how it was designed to it, which is pretty amazing. I mean, whatever. Apparently that's been done before. They've done it with phones. Apparently Hezbollah, in this case, told its people not to use phones because the difference between a phone and a pager is a phone can be tracked and a pager cannot.
Sure.
So the phones were being tracked, and they said, don't use the phones. Here's the brand new pager. Okay, that may not be.
Flip it to the front.
Yeah, I know. It may not go over well. So,
oh my God.
Yeah. So one last thing I wanted to say, I thought was interesting, and we're going to finish on time, was I got a call out of the blue. So I was doing some work on a case or some transaction with another attorney who's located 5-hour flight from me. So I'm on the West Coast, and he's 5-hour flight from me somewhere. And he asked me, and we had never discussed it. He asked me about GTII. Had never come up. We're like literally opposite sides of the country. And his interest was that somebody had approached him, and they apparently had been approached by GTII or somebody else. And he started to research about GTII, and he found the Nevada complaint, and he saw my name on it. And then he saw my name on it. So he contacted me, and we went through it, and I kind of gave him my history of the GTII. But I thought it was amazing, considering this is not like NVIDIA, like some guy on 5 hours away that heard about NVIDIA. Okay. GTII is just some little, right now it's really little. I thought it was really funny that he asked me about it, and whatever. He knew about the receivership, by the way. So he was aware about it. And he was, the way, my interpretation of what he told me was their expectation, there being GTII, etc. Their expectation is a receivership is coming. So they don't think like, and again, I've never spoken to any of these people, so I'm just speculating based upon kind of what my conversation was and my feel. is notwithstanding whatever they're filing, they know they're in deep doo-doo and are acting accordingly. So we were going to go exactly an hour. We're exactly an hour. We are going to try varying the dates and times, and we will obviously discuss legal stuff as it comes up. And we're going to try to force you guys to ask us legal questions, even if we have to come out there and just grab you by the neck. If that's the question, is that an assault, whatever, that's so be it. So be it. We'll do that. I'll let you know, like I said, tomorrow, I promised you that I would give you an update as to when to expect an order. I will promise one way or the other tomorrow, I'll give you an update. And when we have more information after that, after the order is signed and we know what's going on next, we'll discuss that and maybe more looper action. Anything else to add, Monsieur?
No, sir.
You know, I watch on YouTube Fox Live. So it's not the Fox Prime. It's another Fox station. And they interview whatever. And they're pretty pretty down the middle. I kind of actually like them. It's not like regular Fox, not like CNN. It's actually a more of a midline. And so they have interview a bunch of experts. And at the end, they always ask, they have like 30-minute interview. Is there anything else you'd like to say? So that's why I'm asking.
What was Walter Cronkite's sign off? And that's the way it was.
And that's the way it was. And he was very believable.
Yeah. Well,
Problem is
that's when you can trust the news.
Yeah. Well, I mean, it's interesting. Today, there is no one person that everybody trusts.
No.
Walter Cronkite was a guy that I think everybody trusted.
No, not since Dan Rather and then Tom Brokaw. Or not Tom Brokaw.
And then I guess what happened was news became kind of entertainment, and
they blurred the lines.
Yeah, and there was probably a lot more money.
Brian Williams, that's what I was thinking of. Not since Dan Rather blurred the line, and then Brian Williams was really the last vestige of the old guard.
But he got into trouble too, right?
Yeah. Well, he was indulging in the truth, I guess.
Yeah, that's the problem is at this point in time, to be honest, and it's a huge problem, by the way. And
it is. It absolutely is.
I'm skeptical of anything I see, and I do look at the source of everything, and I factor that in. And I don't think it makes a difference whether you're on the left or the right. I think everybody does it.
Well, yeah, I don't believe half of what I see on Twitter. I don't even watch the news anymore. You know what? I don't really have a real source of news anymore. I just kind of put it all together, reading various things and take it from there.
I think the only way you can do it is do it collectively. So you cannot, listen, anybody can do anything they want. So they could look at one source and that could be fine. But I know what I do. And I did this, by the way, as a kid. I just did it differently. But you look at multiple sources and you kind of get some picture of it based on that. Is it 100% accurate? Probably not, but probably close enough. But it is different. It is different than it was in the past. Not saying what we got in the past was accurate. It just appeared to be accurate. Like when Walter Cronkite gave us his news read, I don't know if it was correct, but I didn't challenge it.
I think the difference then was you might not have understood it to be correct, or it might not have been correct, but it always felt like it was objective. You weren't spinning the facts to fit your own narrative. That's what you have going on today. You have news organizations that are spinning the facts to fit their own narrative. I don't care whether it's the right or the left; they're both doing it.
Yeah, the funny part is just thinking back on it. It's when there was limited choice. There was so limited choice. You had 3 networks, right? 2, ABC, NBC, CBS.
Yes.
That was your news sources, but they were much more neutral in their presentation. So even though
they had to be, wasn't there? There was an act that they had to be neutral. There was something that changed in the late 70s. They had to be neutral, and then when that law changed, it was also, I believe, it was the law that allowed networks to something. I have to go back and research.
Well,
Dick Cheney was involved.
There was a point in time where they had to, if they had any candidate on, they had to have an opposing candidate on. I don't know if that's what you're talking about. So
I'm gonna go back and research it because my memory's a little fuzzy on it. But there was a law that was in place that required the news agencies, if you were reporting on the news, it had to have something. I need to go back and look, but I do. It's 8:35, and I got to get going.
Okay. Anyway,
my daughter's going to be standing by herself. And
okay.
Not happy.
Everybody out there, thank you very much. Be well. We'll see you again probably next Monday. Take care. Have a great night.
All right. Talk to y'all soon.
Okay. Yes.
I got to